Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. Today's lockdown edition question is, I'm considering bankruptcy and I have a self-managed super fund. How is that impacted if I go into bankruptcy? So here's how we work through this one. The starting position generally for superannuation and bankruptcy is that superannuation is usually safe from being part of the bankruptcy. That is, it's not included as part of the bankrupt estate's assets, and it can be retained by the person who's going bankrupt. Now, there's some criteria that need to be met in order for that standard position to hold. These are the criteria. The superannuation fund, whether it's self-managed super or even in some other sort of general public offer fund, it has to be part of what's called a regulated super fund. And that is regulated under the SIS Act, the Superannuation Industry Supervision Act. In order to meet this criteria, the obvious question is, how do I find out if my Smsf is regulated? You can ask your accountant or the accountant who set it up for you, and they should be able to tell you if it's regulated. Alternatively, you can have a look for yourself and get a pretty good indication usually on the Superfund Lookup website. So that's quite literally superfundlookup, all one word, .gov.au. You enter the name of your superfund and it should give you some information from there. And or check with your accountant. Now, assuming your super fund is a regulated fund, which most of them are, the next question is, what is the characteristics of the contributions made to the super fund? That is, are they regular and in the nature of ongoing normal type superannuation contributions? Or are there any big lumpy one-off contributions that have been put into the fund, especially recently? So the main principle that this criteria is getting at is most people work out pretty quickly that they might not be able to keep, say, their investment property if they go bankrupt. So they say, okay, I'll sell the investment property, turn the money, turn it into cash, and then put that money into my super, because super's protected, right? So that sort of thing, if it happens very close to bankruptcy and in that sort of way, they would be considered superannuation contributions that cannot be retained by somebody when they go into bankruptcy. But whether you've been working for yourself or working for a company where you're the director or shareholder, or working for a third party and money's been going into your self-managed super fund somewhat regularly, and the contributions in there are of a characteristic that's regular and in the nature of just normal superannuation, if you get the sense of what I'm saying, then they can usually generally be retained by the person if they need to go bankrupt. Now, the next consideration is something specific to SMSFs, and that is when somebody goes bankrupt, they're not able to be the director of a company anymore. So if their SMSF has a corporate trustee, they're no longer able to be a director of that corporate trustee. Similarly, if they go bankrupt, they themselves are not allowed to be a trustee of an SMSF. This is problematic because, to the best of my understanding, the self-managed super rules or laws require that a person who's a member and beneficiary also be a trustee or a director of the corporate trustee. Now, this is definitely something to be speaking with whoever does your SMSF's tax returns or the SMSF's accountant about. I understand that there is a 6 month grace period in order to transition out or make alternative plans or work out what the consequences are if you don't do that transition in time, but definitely something to talk about that you can either talk about with your potential bankruptcy trustee and or your accountant, preferably both. So hopefully, especially with the growing number of SMSFs that there are around, that's some useful information about how SMSFs are dealt with in bankruptcy.